Louisiana prison guards handcuffed a man to a chair and shaved off the dreadlocks he had grown for 20 years as a sacred religious vow. He had handed them a federal court order saying they were not allowed to do that. They threw it in the trash. The warden told him he had no time to call his lawyer. And this week, the Supreme Court of the United States ruled 6-3 that he cannot sue those guards for a single dollar. The case is Landor versus Louisiana Department of Corrections and Public Safety, decided June 23, 2026. It is one of the most important prisoners' rights decisions in years. And if you care about religious freedom, the rule of law, or what accountability actually means, when government officials violate federal law in the most deliberate and defiant way imaginable, you need to understand it. Subscribe right now because this ruling has implications for every prisoner in America who seeks to enforce their federal religious rights against individual officials who choose to ignore them. Let me start with Damon Landor's story because the human facts of this case are important and you need to know them before the legal analysis means anything. Damon Landor is a devout Rastafarian. He has practiced this faith for more than 20 years. As part of his faith, he made what is called the Nazirite vow, a practice rooted in the Book of Numbers in the Bible, a promise to let his hair grow uncut as an act of devotion to God. Over 20 years, his dreadlocks grew until they nearly reached his knees. In August 2020, Landor began serving a 5-month sentence for drug possession at a Louisiana state prison. For the first 4 months of his incarceration, he was held at 2 different facilities. Both allowed him to keep his hair long or to wear it under a covering called a Rasta cap. He had no trouble. He completed his religious observance without incident. Then, with exactly 3 weeks left in his sentence, Landor was transferred to the Raymond Laborde Correctional Center. When he arrived, he did what any informed prisoner in his situation would do. He told the intake guard he was a practicing Rastafarian. He provided documentation of the religious accommodations he had received at his prior facilities. And he handed the guard a copy of a binding Fifth Circuit Court of Appeals ruling from 2017 that specifically found that Louisiana's policy of cutting the hair of Rastafarian prisoners violated the Religious Land Use and Institutionalized Persons Act, a federal law. This was not a letter from his lawyer. It was not a personal claim. It was a published opinion from a federal appellate court specifically addressing his situation in his state. He handed it to the guard as evidence that what they were about to do was illegal under federal law. The guard threw it in the trash. Landor pleaded with the warden. The warden demanded written authorization from Landor's original sentencing judge. When Landor said he could call his lawyer to get the paperwork, the warden replied, "Too late for that." 2 correctional officers held Landor down. He was handcuffed to a chair, and they shaved his head. In Rastafarian belief, the dreadlocks represent a spiritual covenant with God. Cutting them is not merely a physical act, it is the severing of a sacred bond. Landor described what happened as being uncrowned before God. His lawyers used that phrase in their Supreme Court briefs. After he finished his sentence, Landor sued the prison warden and the guards under the Religious Land Use and Institutionalized Persons Act, known as RLUIPA. He also filed state court claims for negligence, emotional distress, and violation of the Louisiana Constitution. Here is the response of the Louisiana court system and the Fifth Circuit Court of Appeals. Every court that heard this case condemned what happened to Landor. Not one judge who has ever written an opinion in this case said the prison guards were right. The Fifth Circuit panel that ruled against him said it did so emphatically condemning the treatment that Landor endured. Even the Louisiana Attorney General in her briefs to the Supreme Court said the state condemns what happened in the strongest possible terms. Nobody defended the guards' conduct. Nobody said shaving a prisoner's religiously sacred hair in defiance of a federal court order is acceptable behavior. The court said, "What happened to you was wrong, and we cannot give you any remedy for it. You lose." If you are finding this important, subscribe right now, because I am about to explain the technical legal reasoning that produced this result, and understanding it is essential for evaluating what the law actually means when it says it protects your rights. Here is the legal framework. RLUIPA was enacted by Congress in 2000. It says that no government shall impose a substantial burden on the religious exercise of a person residing in or confined to an institution, even if the burden results from a rule of general applicability, unless the government demonstrates that imposition of the burden on that person constitutes the least restrictive means of furthering a compelling governmental interest. In plain language, if you are in prison, the government has to have a very good reason for interfering with your religious practice, and the reason has to be narrowly tailored. It cannot just be convenience or institutional preference. If Louisiana says all prisoners must cut their hair, and a Rastafarian prisoner says cutting my hair violates my religious vow, Louisiana has to prove it has a compelling reason for the haircut rule and that there is no less restrictive alternative. The Fifth Circuit in 2017 found that Louisiana's blanket haircutting policy failed this test as applied to Rastafarians. That ruling was the federal court opinion Landor handed to the guard at Raymond Laborde. The guard was aware of it, held it in his hands, and threw it in the trash. The law was clear. The violation was deliberate. So why can Landor not collect any money from the people who violated his rights? The answer is a constitutional technicality that sits at the intersection of two different congressional powers. Congress has the power to regulate directly under several constitutional provisions, including the 14th Amendment's Enforcement Clause, the Commerce Clause, and others. When Congress uses those direct regulatory powers, it can impose liability on anyone who violates the rules it creates. But Congress also has what is called the Spending Clause power. Under the Spending Clause, Congress can give money to states and attach conditions to that money. States that want the money have to comply with the conditions. States that do not want to comply can simply refuse the federal funding. The relationship is understood in the law as essentially contractual. The federal government offers a deal. The state accepts the terms as a condition of the funding. RLUIPA was enacted under the Spending Clause. Congress said to state prisons, if you accept federal funding, you must protect the religious rights of your prisoners. Louisiana's prison system accepted federal funding. It became bound by RLUIPA's requirements. But here is the problem that Justice Gorsuch identified and built his majority opinion around. A contract between two parties, the federal government and the state prison system, can bind those two parties. It cannot automatically bind third parties who were never part of the agreement. The individual guards at Raymond Laborde Correctional Center are not the state of Louisiana. They did not sign any agreement with the federal government. They did not personally consent to being held liable under the terms of RLUIPA. Under the contract principles that apply to Spending Clause legislation, you cannot hold someone liable for breaching a contract they never entered. Gorsuch's key quote is worth reading directly. He wrote that under the Spending Clause, Congress lacks regulatory authority to impose liability on them directly and must depend instead on consent. And he wrote that Landor's case cannot proceed against the individual guards any more than a breach of contract action might proceed against a defendant who never formed a contract. The majority also addressed what Landor needed to show to get around this obstacle. The majority said Landor would need to show that each individual guard had personally and voluntarily agreed to be held liable under RLUIPA, not the prison, not the state, each guard individually. Needless to say, no prison guard has ever signed a document saying they personally consent to being sued for damages if they violate a prisoner's religious rights under federal law, so the case ends there. Hey, 73% of people watching right now are not subscribed. This ruling affects not just Rastafarians, but every prisoner in a state facility who tries to enforce their federal religious rights against individual officials. Subscribe right now so you understand the full scope of what just changed. Let me explain the comparison that makes this ruling so difficult to accept on its face. Congress also passed a closely related law called the Religious Freedom Restoration Act, known as RFRA, in 1993. RFRA and RLUIPA use almost identical language. They were designed to achieve similar purposes, but RFRA was enacted not under the Spending Clause, but under Congress's power to enforce the 14th Amendment. In 2020, the Supreme Court ruled that RFRA does allow damages suits against individual government officials. So here is the situation we now have. A Muslim man held in a Federal Bureau of Prisons facility who faces religious rights violations by individual prison staff can sue those staff members personally for damages under RFRA. A Rastafarian man like Damon Landor, held in a state facility, who faces the exact same type of violation by the exact same type of officials, cannot collect $1 under RLUIPA because of the different constitutional foundation of the statute. The law that was supposed to protect prisoners' religious rights in state institutions now leaves those prisoners effectively without a personal remedy against the individuals who violate those rights, while prisoners in federal facilities retain that remedy under a statute with nearly identical language. Let me now address Justice Jackson's dissent directly because it is worth understanding at length. Jackson, joined by Sotomayor and Kagan, called the majority's position peculiar and warned that it will leave prisoners whose religious rights are violated while incarcerated remediless. She made three core arguments. First, she challenged the majority's use of contract principles to analyze a federal statute. RLUIPA is not a contract, she wrote. It is a law. Statutes are not contracts. They are binding legal obligations created by the legislature and enforced through courts. Treating RLUIPA as a contract and then applying contract law's party-to-party limitation distorts the nature of federal legislation and creates a doctrinal framework that could undermine many other statutes enacted under the spending clause. Second, Jackson argued that the majority's reasoning would have consequences far beyond RLUIPA. Many federal laws protecting civil rights are enacted wholly or partly under the spending clause. Title IX, which prohibits sex discrimination in education at institutions receiving federal funding, uses a similar structure. Title VI, which prohibits racial discrimination, has a similar basis. If the majority's contract principles logic is extended consistently, Jackson warned, it could undermine federal authority in many areas that Congress has historically legislated through its spending power. Third, Jackson addressed the practical reality of prison life with unusual directness. She wrote that prison employees know when they sign up to work at a state prison that they must obey the law or face the consequences the law prescribes. She rejected the majority's framing that individual guards needed to personally consent to liability because they were never part of any agreement. They knew they were working under federal legal requirements. Throwing a federal court order in the trash and shaving a prisoner's sacred hair with 3 weeks left in his sentence is not a misunderstanding of the law. It is a deliberate act by someone who believed they could get away with it. And after Landor, they were right. Jackson's final warning was perhaps the most pointed. She wrote that encroachments on prisoners' statutory rights are likely to happen with fair frequency, as state-empowered prison officials will have little incentive to abide by federal law, even if it is handed to them on a piece of paper. That line is a direct reference to the physical paper Landor handed the guard, the paper the guard threw in the trash. She is saying, the majority's ruling tells every guard in every state prison in America that they can do exactly what those guards did to Landor, and the only consequence will be a policy change at the institutional level, not a dollar out of their own pockets. Now let me tell you what remains available to Landor and what the broader implications are. Landor has not exhausted all his options. He has state law claims still pending in Louisiana state courts for negligence, infliction of emotional distress, and violation of the Louisiana Constitution. These claims are separate from his RLUIPA claim and were not resolved by the Supreme Court's decision. The journalist Justin Juvenal, who has covered this case extensively, observed that Landor may still be able to pursue his claim in state courts. Whether Louisiana state courts will give him meaningful relief remains to be seen. Louisiana Attorney General Liz Murrill said after the ruling that the state has its own laws protecting religious freedom and has already changed its grooming policy in response to Landor's case. That is something. But it is not money. It is not accountability for the individuals who held a man down and violated his religious rights while holding a federal court order saying they could not. What does this mean for other prisoners? It means that every prisoner in a state correctional facility who faces a deliberate violation of their religious rights by individual guards or wardens now has a significantly reduced federal remedy. They can still sue the institution, the state corrections department, for injunctive relief, meaning a court order requiring the institution to change its practices. But they cannot pursue money damages from the individuals who personally committed the violation. This affects not just Rastafarians but Muslim prisoners who want to maintain beards or observe prayer times, Jewish prisoners who observe the Sabbath, Native American prisoners who practice indigenous spiritual rituals, Christian prisoners who need access to religious services, anyone who relies on RLUIPA to protect their religious practice in a state prison now knows that individual officials who violate those rights face no personal financial accountability under federal law. There is one path to fixing this. Congress can amend RLUIPA. The majority was careful to say that the problem is how Congress chose to enact RLUIPA under the spending clause. If Congress reenacts the relevant provisions under a different constitutional authority, or if it adds explicit language giving courts authority to impose personal liability on individual officials, the outcome in a future Landor-type case could be different. The National Catholic Register, analyzing the case, made exactly this point, noting that Landor has done something important by exposing a real gap in the law all the way to the highest court in the country, and that the question is whether Congress is paying attention. Let me close with the contradiction at the heart of this ruling. The same 6 conservative justices who formed the majority in Landor have been among the most aggressive defenders of religious freedom in recent terms. They sided with a football coach who prayed on a public school field after a game. They sided with a Christian web designer who refused to create wedding websites for same-sex couples. They sided with religious parents who wanted to opt their children out of elementary school lessons featuring LGBTQ-themed books. Religious freedom, in case after case, has been one of the signature commitments of this conservative majority. And then Damon Landor arrives, a man who practiced his faith for 20 years, who kept his religious vow through 2 prison facilities without incident, who was 3 weeks from the end of his sentence when guards deliberately violated his rights in defiance of a court order. And this majority, these same justices who have expanded religious freedom rights so dramatically in other contexts, found a technical constitutional reason why he cannot collect $1. The reason, as I have explained, is the spending clause. RLUIPA was enacted under a constitutional power that carries structural limits. Those limits, in this case, produced a result where the right was violated, the violation was documented and condemned by every court that considered it, and the people who committed the violation walk away without paying a dime. Damon Landor said after the ruling, "I am disappointed, but not defeated. What happened to me violated my faith and my dignity. I will continue pursuing accountability. What happened to me should not happen to anyone else. He is right on all counts. What happened to him should not happen to anyone else. And with this ruling, there is now less to prevent it from happening again." Subscribe right now because I will be tracking any congressional response to this decision and any developments in Landor's state court claims as they proceed. This is educational content only, not legal advice. For any prisoner or family member dealing with religious rights violations in a correctional facility, consult a civil rights attorney immediately.